Chair Moeller, would you like to move to recommend that House File 3509 be placed on the general register?
Thank you, Madam Chair. That is my motion, and there will not be any Taylor Swift lyrics in the presentation of this bill today.
Not on purpose, anyway. Chair Moeller, to your bill.
Thank you, Madam Chair and members. So this is an issue that I have been working on for over a decade in my other job as a prosecutor, and it has to do with protecting privileges and privacy of victim survivors of crime. The privilege statutes are in a separate chapter, Chapter 595. They're not specific to criminal or civil law, so these are privileges that apply in all kinds of court circumstances. And I think most people on this committee are probably familiar with the attorney-client privilege, or the privilege you have as a patient for your mental health records or your medical records. In statute, we also have privileges for the conversations between a sexual assault advocate and victim survivors of sexual assault, and a privilege for domestic violence victim survivors and their advocates. These communications, whether it's attorney-client or the kind of communication you'd have with your doctor or as a victim to these community-based advocates, are meant to protect information because we want people to fully be able to communicate whatever issues they're having with those people for whom they're having that conversation. I did have a testifier, and she was unable to come because she has court today. And I'm just going to read a portion of what she would have said had she been here. Her name is Raina Alexander, and she represents a lot of the domestic violence and sexual assault community-based programs in the state through her job at Standpoint. She says, domestic violence is an underreported crime, and among the many reasons victims give for not reporting or seeking help is the loss of anonymity and privacy that comes with engaging in the criminal justice system. Access to confidential advocacy services, crisis support, and ongoing counseling is critical to the health, recovery, and safety of domestic violence victims. Working with an advocate can provide a safe, confidential, and non-judgmental opportunity for a victim of domestic violence to consider all available options while addressing any pressing needs, including crisis support and access to services in responding to the trauma they have experienced. In 2022, Minnesota Supreme Court decision, the sexual assault counselor privilege was found to be an absolute privilege. However, the domestic abuse advocate privilege was found to have broad exceptions, including that the court could order disclosure of the advocate's records and conversations. This means that if a domestic violence victim seeks support from a domestic abuse advocate, their conversations are not strictly privileged. The court could order disclosure. Considering between 40 and 45% of women in abusive relationships will also be sexually assaulted during the course of the relationship, if the same domestic violence victim was to speak to the sexual assault counselor, that conversation would be strictly privileged. In addition, because of the lack of funding, many programs service both victims of domestic violence and sexual assault, which means a victim could tell their story to one advocate, and the part of their story about sexual violence would be absolutely privileged, and the part about domestic violence would not. This leaves victim survivors and domestic violence advocates unclear about whether their conversations are absolutely privileged. Victim survivors often express feeling re-victimized by the system when their records from a domestic violence program are sought. And so that really, members, really lays out sort of the discrepancy that we have in the law right now with some of these privileges like sexual assault privilege, and then this one which allows for a court to basically invade the privilege that a victim has with an advocate. I do know that there is a letter of opposition in your packet today from MacDill. I believe they're going to testify, and I think there is a fundamental misunderstanding in that letter. Clearly, if the state has information, if this was somebody working for the state, the prosecutor is obligated to disclose that information, either under the Brady decision from the Supreme Court or under Rule 9 of the Minnesota Rules of Criminal Procedure. These conversations are with community-based advocates, and if you look in the bill, on line 4.19, it makes clear that these are community-based advocates. Often they're nonprofits. They're third parties. They're not part of the litigation. And there's also in your packet some information from Violence Free Minnesota and the Minnesota Alliance on Crime. There describes the difference between community-based and system-based advocates. And if you look at the boxes there, I think it's the fifth one down, really describes the difference between community-based and system-based. So again, these are not state employees, they are not state actors. It's just like somebody going to their doctor and telling them information that's privileged. We should make sure that we're closing that loophole for domestic violence victims and survivors because they deserve it. Thank you.
All right, we've got a couple public testifiers signed up. First, I have Shauna Kiefer. Please introduce yourself and then proceed with your testimony.
Thank you. My name is Shauna Kiefer. I am here today on behalf of the Minnesota Association of Criminal Defense Lawyers. I was a public defender in Hennepin County for about 10 years. I've been an attorney for 16 years. This bill involves proposed changes that could potentially legislate away a defendant's right to due process in cases involving allegations of domestic abuse. Knowing that this bill touches on domestic violence, I want to acknowledge that my testimony today in no way diminishes this weekend's tragedy in Burnsville. I've handled thousands of cases all over the state in my role as an attorney for the past 16 years. Cases involving allegations of domestic violence are unlike any other when it comes to witness recantations, inconsistent statements, and even at times prosecuting agencies issuing arrest warrants for uncooperative victims. This proposal would further add to these potential manipulations of a domestic victim's statements when they're presented to a domestic violent advocate. There should be a process that allows a judge to conduct an in-camera review to review a domestic advocate's notes as they pertain to statements by an alleged victim of domestic violence. Should this bill pass, a domestic violence advocate or the victim of a domestic violence would have the ability to prevent a defendant from obtaining relevant material exculpatory evidence in order to present a full defense. This proposal is ripe for manipulation and could result in wrongful convictions. For example, evidence that would provide for a legitimate claim of self-defense could be withheld if the alleged victim did not consent to disclosing certain pieces of that information. Domestic abuse advocates are not therapists or counselors, and therefore the current statute regarding their opinion or information from or about a victim is different than the provisions for a sexual assault counselor or therapist. The existing statute provides protection unless ordered by the court. The current statute recognizes the differences with such information as it should. This proposal removes even allowing a court in camera with protective orders available from reviewing an advocate's information from or about the alleged victim. And this infringes on the defendant's due process rights, especially the right to confrontation. All statements provided to a domestic violence advocate should be reviewed in camera by a judge pursuant to parity request to determine if any statements are exculpatory and should be disclosed with a protective order to the attorneys in the cases involving allegations of domestic violence. Notice to the alleged victims should be given in accordance with the new rules of criminal procedure. The current statutory provision provides this protection and should not be amended. While we would never want to chill disclosure to domestic abuse advocates, it should not come at the cost of legislating away a defendant's right to due process and their ability to present a full defense.
All right, thank you for your testimony. Next on the list, I have Guadalupe Lopez. Welcome to the committee. Please introduce yourself and proceed with your testimony.
Bonjour, my name is Guadalupe Lopez. I'm the Executive Director of Violence Free Minnesota, the statewide coalition to end relationship abuse. Hello, good morning, Madam Chair Becker-Finn and members of the committee. I'm here today to support House File 3509. Our advocates need confidentiality because advocate-client relationship is built on trust and non-judgmental support. I will direct your attention to lines 4.18 to 4.23. You can see that the domestic violence advocate is defined as a person working as an employee or supervised volunteer for a community-based domestic abuse program. It explicitly states that the advocate cannot be an employee of law enforcement, prosecutor's office, or government agency. This difference between community-based systems and systems-based advocates is a common misunderstanding, but we must stress that we are in agreement that the state has legal and moral obligation to disclose all defense favoring evidence that it has. In this case, however, our advocates are not the state. Please see the handout that was sent in for more details on the defense between community-based and systems-based advocacy. The role of our advocates is to provide a critical support to people trying to maintain their safety from domestic violence. Our advocates are connected to victim survivors. We connect them to healthcare, shelter, and other services around the state. They meet with victim survivors at all hours of the day and night in places like hospitals, their home, clinics. They help victim survivors manage their schedules and establish childcare, and may help victim survivors navigate complex civil, family, housing, criminal courts, and other systems. In order to do this most effectively, victim survivors need to trust that the things that they are sharing with the advocate will not come back to hurt them. At Violence Free Minnesota, we believe that this bill would actually strengthen protections for criminal defense rather than erode them. This is because domestic violence is underreported and under-prosecuted crime. Many times, victims do not seek assistance from advocates or from the legal system at the first instance of violence in their home. A defendant may currently be facing one count of strangulation, but it is not uncommon for that victim will have disclosed multiple other physical assaults to their advocates. Under this law, these statements would also be confidential. Additionally, the victim survivors themselves are often charged with crimes connected to their victimization. For example, a victim survivor may be drunk when their abuser starts hurting them, and so the victim survivor makes a hard and illegal choice to drive away for safety. Victim survivors may use illegal substances, both as coping mechanisms or by force by the abuser. They may commit crimes of survival like shoplifting or writing a bad check, and these are all things which the victim survivor may disclose to their advocates for survival. So their advocate can get a full picture of what their life is like. These are all the things that could happen to be criminally charged for if the prosecutor can subpoena their records and discover the omissions. We fully support this bill, and we fully support strengthening the relationship between advocates and their clients through the legal guarantee of confidentiality. Thank you.
Thank you. Are there any other members of the public wishing to testify on this bill? Right, seeing none, we'll move on to member discussion. Representative Scott.
Thank you, Madam Chair. Representative Mueller, you said you've been working on this for a decade. Why has it taken so long? Is it because of the pushback about possible exculpatory evidence? What's the rub there?
Yeah.
Chair Mueller.
Yeah, Madam Chair and Lead Scott, thank you for the question. Because the courts for decades have been saying that they can do an in-camera review. So a defense attorney may say, oh, I think this victim is getting mental health records. I would like or mental health treatment, or seeing an advocate. I would like the court to do an in-camera review and let us know if there's anything in that information that's exculpatory and turn it over. And courts had traditionally been conducting that in-camera review. And the Minnesota Supreme Court in the 2022 decision that I mentioned, the Hope Coalition case, said a privilege is a privilege, and that is not, we shouldn't be just doing these in-camera reviews anymore. The due process rights that somebody has is against the state actor. These are third parties. And I think some of the sort of tradition of granting these in sexual assault and domestic violence cases has to do from the myth that these victims shouldn't be believed. I really think that stems from that sort of belief that victims of these crimes shouldn't be believed, and therefore we should comb through all of these privilege records and find out if they made that one statement that should be disclosed to the defense.
Representative Scott.
Thank you, Madam Chair. Representative Mueller, so walk me through a scenario where an alleged victim tells their advocate that maybe some exculpatory evidence, such as, I've dealt a lot with family law in my time down here, and I know the power of a false accusation in family law court. So if the victim says, I'm doing this because I want custody of the kids, and this will be one way of getting this on the record, whatever, so to speak. And then they don't disclose, the victim doesn't disclose that to the prosecutor or doesn't disclose that in some way, and that's sort of exculpatory evidence. What happens? That just, nothing is actionable there?
Chair Moeller.
Thank you, Madam Chair. Representative Scott, these are privileged communications, just like an attorney-client privilege would have. And that Hope Coalition case that I mentioned in 2022, the Minnesota Supreme Court talked about that. I don't know if any advocates are here or Director Lopez wants to speak to that about if victims say exculpatory things like that to their advocates, but the bottom line is those are privileged communications with a third party who's not a state. Now, I think there's still some situation where there would be obviously constitutional rights and due process concerns trump anything else. And the Hope Coalition case talked about that. In that particular case, there wasn't a due process violation. So I think the courts have left open if some narrow situation where there could be a situation like that. But really the bottom line is those are privileged, just like attorney-client communications.
Okay, thank you. Representative Scott. Okay. Representative Curran.
Thank you, Chair. And my question will be for Ms. Kiefer from MacDill, if she wants to make her way down. And Chair Moeller, thank you for bringing this bill forward. In my experience as a deputy, this reminds me of showing up at someone's home where a woman was unfortunately abused from head to toe. And there was no sexual assault involved, but clearly this was something that had been ongoing, and you know, just an awful thing for somebody to have to relive and talk about. And I mean, at the end of our interaction, all she really wanted was a hug and to know that someone would be brought to justice and that she would be safe. And all of this happened in front of her children. And so, you know, I say this because, you know, we're talking about very serious situations, very traumatic situations. So my question for MacDill is, why does MacDill believe that domestic violence survivors deserve less protections than other privilege holders like survivors of sexual assault?
Ms. Kiefer.
Thank you. I have to remember how to do this formally. Chair Becker Finn. And as to your question, Member Curran, we don't believe that. We believe all defendants deserve a fair right to trial and that they're presumed innocent unless and until they're shown guilty. I'm so sorry that you had that personal lived experience, and I'm so sorry that so many women do. But this isn't about that. This is about, as a public defender, I had a victim that recorded their conversation with the advocate saying, I don't want to go forward with this case. And the prosecutor was representing to me that the advocate said that they did want to go forward and that the evidence matched that case. Because that victim had recorded this statement and sent it to me randomly, I could show that prosecutor that the victim advocate was misrepresenting what this person said. But if we take away the right to confrontation, which is one of our fundamental rights, it's what this country was established on, was that we're going to start off believing that you are innocent unless and until you are proven guilty. And so no, I absolutely believe with all my heart that people that commit serious crimes should face the consequences for it. And I do believe that many women are diminished and not given their voice, and I certainly would never want to do anything to take away from that. But I do think that there should be a mechanism whereby a judge can review what a victim advocate is saying to see whether or not they're representing what that person has said. Another contention that I had with Ms. Moeller's representation about the advocates not working for the prosecutor, they come to court, they quite often, in the cases that I've had, sit down with the prosecutor to gather their statements together, not always, but quite often. And so while we have these huge protections, which hopefully would somehow someone would know that these rights to Brady and the rights under Rule 9 had been violated and upheld, there's really no way to do that unless a judge is able to determine that. But no, I don't want to silence any voices, but I also don't want any people wrongfully convicted or any defendants treated lesser just because the nature of what they're accused is so gross that we decide we're not going to give them a fair shot.
So a couple things. You might want to be careful in characterizing what Chair Moeller has said as a misrepresentation. Those advocates don't necessarily work for the state, so you might want to be careful.
Not all of them. I'm sorry if I
nope,
said that.
Nope, you just did. So I'm going to correct that because that's not how you're going to speak to Chair Moeller, because that just isn't true. That advocates, just because the advocate is there with the victim and the prosecutor also wants to speak with the victim, doesn't mean that they work for the state. They are separate. And we do have a handout here on the difference between community-based advocates and system-based advocates, and I'd encourage you to take a copy of that when you leave today. I also will just speak as someone who was also a domestic violence prosecutor, and the role that I played was that I was one of the kind of the closest sort of a boots on the ground prosecutor working in the Domestic Abuse Service Center, where I literally worked side by side and daily with community advocates and spoke directly and listened directly to victims. I was one of the few prosecutors in the office where a victim or a person could call directly and speak to an attorney. And so I just want to correct, something that was in this letter and the conversations that have been happening around this issue, that a victim survivor has the right to change their mind. They may at one point not want to go forward, and later on circumstances could change and they want to go forward. Was very common on the cases I worked on, was that a person may initially, right after that extreme violence has happened, they do want the case to go forward because they want to disrupt the violence. And then as time goes forward, maybe they've got 3 kids with that person, and that person's income was helping them to keep their housing. And we need to trust victim survivors to know best how to keep themselves and their children alive. And so a victim has the choice. It is always their choice. And their decision can change as the process goes forward. So just because someone decides later on, 3 months later, it is no longer in the best interest of keeping me and my family safe, that I'm going to no longer participate in the prosecution, doesn't mean that they were lying. It does not mean that they were lying. It means they are making the choice that they need to make to stay alive. And we all need to trust that they know better than any of us, than law enforcement, than prosecutors, than anybody in this room, how to stay alive, because they're the only ones who know their situation. So I just want us to be really careful with all this, using the word allegedly and recantate. Like, there are many reasons why a person may change their mind about how something might move forward. And I understand it's really complicated and not everyone has the lived experience every day of working around domestic violence, but I just want us to be really careful in assigning motives for why a person may or may not continue with the prosecution process. Representative Curran, you have the floor.
Thank you, Chair. And I don't have any other questions, but just sort of in response to the answer, I simply disagree. I find the opinion of MacDill quite appalling, to be completely frank with you. And my question was if domestic violence survivors deserve less protections than sexual assault survivors. And the answer I received was that defendants have constitutional rights. I am not disagreeing about constitutional rights. I think those are, they are in place. I think those are protected. I think the right to a fair trial and all of the access that defendants have for a fair case, I think that stands, even with this bill moving forward. I don't see this as a bill to protect defendants. I see this as a bill to protect the private information of people who have been through trauma. And that is the reason why I strongly support it. And again, I think, I just thank you, Chair Becker-Finn, for your comments on that as well. Thank you.
Representative Johnson.
Chair Becker-Finn, Representative Moeller, thank you. Chair Beckerfin, thank you for your comments. These advocates are there not for the courts, not for the prosecutors. They're there for the victims. Many times, in my 27 plus years in law enforcement, I don't know how many thousands of domestics I've been at. And generally, there's one theme. The perpetrator is doing this for control and by intimidation. And these victims, they've lived a long life of it, unfortunately. And they finally got to the point where they called for help. And that call for help is usually with law enforcement because of a very traumatic situation. Now, law enforcement has worked for years getting very highly trained advocates that help those victims. They don't help with the prosecution other than talking to the victim and getting them through having to live that event again in court. But they provide the services needed to help them live with it, help them get through it so they can have a better life and a safer life for them and a lot of times for their kids. Representative Moeller, thank you for bringing this forward. These advocates are no different than what these victims say if they go confess to their priest, which is also protected. So these advocates are the angels in the system helping the victims. Thank you.
Thank you for your comments, Representative Johnson. I often think of advocates prevent more homicides than I think anyone else in the system because they work so closely to the details to know exactly what victims need in these situations. So, Representative Moeller, closing comments.
Thank you, Madam Chair and members. Yeah, just really would encourage anyone opposed to read the Hope Coalition case from 2022 because this isn't about the right of confrontation, cross-examining witnesses. This really isn't due process because that's a right a defendant has against the state. Again, these are third party. And just to emphasize what Director Lopez said here, that this applies universally. So sometimes prosecutors try to get privileged information in like child protection in cases, and they're denied as well, and they should be denied. This is really about protecting those communications that are so important for survival. Domestic violence victims, survivors, deserve no less protections than anyone else, and I look forward to your vote. Yes, thank you.
All right, thank you. Chair Moeller renews her motion that House File 3509 be placed on the general register. All those in favor, please say aye. 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 Opposed? Motion prevails. Thank you, Chair Moeller.